right? So if the prosecutors have done something improper, you can invade the secrecy of the grand jury, discover that, and then use that as a basis for a motion to dismiss. It almost never happens that you get even to the inquiry phase. But once again, Comey has an unusually strong case here.
Yeah, and it's because of what we said was the fundamental problem at the center of this case, right? Halligan returned an indictment that is so vague that it could fit multiple fact patterns. Welcome to Law and Chaos, where the Trump administration is trying to starve children. The prosecution of James Comey is falling apart. Who'da thunk it? And as of now, there are still no National Guard troops on the ground in Illinois or Oregon. We've got a lot to cover, so let's get after it. Happy Friday, Chaos Monkeys. I'm Liz Dye, and with me, as always, is Andrew Torres. Andrew, how are you?
I'm great, Liz. How are you?
I mean, it's a wild week. It's a wild week.
Every week is a wild week, but yeah, I hear you.
My local council member just got indicted. It's deeply embarrassing, and not even in a normal Baltimore way, in a crazy way. I'll not link to it in the show notes, but y'all got the Google. Anyway, the news cycle this week was crazy all over the place, as per. First, we're going to talk about the Trump administration's effort to take advantage of the shutdown to starve children and burn down the federal bureaucracy. Then we're going to catch up on the government's efforts to flood the streets with soldiers for a fake emergency. And then we will catch up with our favorite Florida insurance lawyer who read How to Prosecute Her for Dummies and thinks she's hot shit. But first, Aubrey Drake Graham continues to be amazing.
I mean, he is never going to replace Justin Baldoni, in my heart at least, for delightful, distracting content.
Yeah, I think we covered it on the show when he filed that dumb case against UMG for defaming him by airing Kendrick Lamar's diss track.
It's so gangsta.
Oh, yeah, you blend.
But we did not cover Judge Jeanette Vargas's delightful order of dismissal from 3 weeks ago. Here's the opening paragraph. This case arises from perhaps the most infamous rap battle in the genre's history, the vitriolic war of words that erupted between superstar recording artists Aubrey Drake Graham, Drake, and Kendrick Lamar Duckworth, Lamar or Kendrick Lamar, in the spring of 2024. Over the course of 16 days, the two artists released 8 so-called diss tracks with increasingly heated rhetoric, loaded accusations, and violent imagery. The penultimate song of this feud, Not Like Us by Kendrick Lamar, dealt the metaphorical killing blow. The song contains lyrics explicitly accusing Drake of being a pedophile, key of A minor, set to a catchy beat and a propulsive bass line, which I agree. Not Like Us went on to become a cultural sensation, achieving immense commercial success and critical acclaim. And I think her clerks had a lot of fun with that one.
Yeah. So Judge Vargas granted the motion to dismiss for a failure to state a claim and for being a punk-ass little bitch.
Real quote?
Well, maybe not that last part. Anyway, that should have been the end of the story.
But it is not, because Drake filed a notice of his intent to appeal on Wednesday. He's actually going to drag this dumb turkey of a lawsuit to the Second Circuit Court of Appeals and invite them to compose their own diss track, which is a thing you can do when you have endless money, but you probably shouldn't.
Yeah. Okay, that was fun, but the government shutdown is not fun, no. Particularly when the executive branch is run by absolute psychopaths trying to starve people as a bargaining chip. So the first case we're going to talk about here involves SNAP benefits.
Right. SNAP, S-N-A-P, stands for Supplemental Nutritional Assistance Program. It is relied on by approximately 41 million Americans. That is more than 9% of U.S. households. Approximately 1 in 6 children in this country gets fed through SNAP. So, naturally, the Trump administration hopes to leverage that program to force Democrats to cave on the budget.
And by cave, you mean allow the GOP to gut health insurance subsidies? It's so disgusting.
Yeah.
Okay, so there is a $6 billion contingency fund specifically for SNAP. And in fact, there was a plan published in 2019, the last time Trump was in the White House, and in anticipation of a shutdown. That plan said that this pot of money could be used to keep SNAP benefits going. But now the Trump administration has deleted the entire document and produced a new one saying it would be illegal to use this $6 billion to feed kids. So they're going to cut off SNAP funds as of Saturday. That's tomorrow.
At the same time that this administration is bribing farmers hurt by the tariffs that Donald Trump imposed and paying ICE goons $50,000 signing bonuses to go beat up brown people. It's just cartoonishly supervillain evil. Here's what the USDA website says right now. Senate Democrats have now voted 12 times to not fund the food stamp program known as Supplemental Nutrition Assistance Program, SNAP. Bottom line, the well has run dry. At this time, there will be no benefits issued November 1. We are approaching an inflection point for Senate Democrats. They can continue to hold out for health care for illegal aliens and gender mutilation procedures, or reopen the government so mothers, babies, and the most vulnerable among us can receive critical nutrition assistance.
Hatch Axe is a way of life.
Yeah.
All right, we don't have time for it. So on Tuesday, a coalition of blue states sued in federal court in Massachusetts. It's a 2-count complaint under the Administrative Procedure Act, and they've asked for a temporary restraining order barring the government from cutting off SNAP benefits.
Right. So the Administrative Procedure Act, the APA, is a law that provides for judicial review of executive agency actions that are either unlawful or have been implemented in a way that is arbitrary and capricious. And here, the plaintiff states are arguing both of those criteria, right? The government filed a reply on Wednesday night saying that they can't spend the money because then that money might not be there for disaster relief.
Because 41 million people going without food isn't a disaster. Okay.
Yeah. The case has been assigned to Judge Indira Talwani, an Obama appointee. We like her a lot. She held a hearing this morning and raked the government over the coals. She said, Congress has put money in an emergency fund, and it is hard for me to understand how this is not an emergency. And I want agency action, not lawyering. It was great.
Indeed. So no order has issued as of this recording, but Judge Talwani set a hearing for November 13th, i.e., 2 weeks hence, which would be the length of a TRO. So I assume an order is imminent. And speaking of arbitrary and capricious action, let's shift to the Northern District of California courtroom of Judge Susan Ilston, whom we also like a lot.
Yeah, she is a Clinton appointee.
Yeah, I think she counts as an old bull or a mature. You know, we're going to dish this analogy. We use it a lot for male judges, but let's just say Judge Ilston has been at this a long time, and she is not here for the DOJ's bullshit.
No.
Judge Ilston is presiding over a case brought by 10 labor unions representing federal employees, and they hope to block the Trump administration from taking advantage of the shutdown to illegally fire thousands of civil servants.
Yeah, the last time we talked about this case, we said how crazy it is that normal people have to know what a reduction in force is.
See also the Federal Tort Claims Act and the Federal Vacancies Reform Act and the Administrative Procedure Act, the Alien Enemies Act, the Tucker Act. Like, we could go on.
Too many to list. A reduction in force, a RIF, is basically a mass firing. And because it's the federal government and not, say, Amazon, there are rules that govern how federal agencies can terminate staff, both because civil servants have specific legal protections against being fired and because dumping thousands of employees at once has adverse effects on local governments.
Right. But Trump and his shadow vizier Russ Vought have taken the position that the shutdown means all those laws are null and void and they can mass terminate employees at will. And Trump wasn't subtle about it. He posted, I had a meeting today with Russ Vought, he of Project 2025 fame, to determine which of the many Democrat agencies, most of which are a political scam, he recommends to be cut, and whether or not those cuts will be temporary or permanent. I can't believe the radical left Democrats gave me this unprecedented opportunity. Trump said over and over again that he was cutting, quote, Democrat programs, and votes said that the targeted firings would exceed 10,000 people. And predictably, it's been absolute carnage. People don't know if they're RIFed since they can't check their government emails during a furlough. They don't know if they still have health insurance. It's a nightmare.
Yeah. So the plaintiff unions sued under the APA, and the government's response was basically, we're not saying that votes Rumspringa on RIF laws is right, but you guys don't have standing to sue anyway. Which is bizarre, since the unions represent federal employees who lost their jobs illegally. Obviously, they have standing to sue. And Judge Ilston agreed and issued a preliminary injunction on Tuesday. She found that the firings were arbitrary and capricious. Thank you, Grandpa Twitter Fingers, for making that one easy, and violated the law. Okay, so that's good. But there are a few more things here to note. First, the administration has been demanding that plaintiffs post a bond commensurate with the cost that the government might be out if they ultimately prevail. We've seen them try this argument a lot. The point is to impose millions or possibly billions of dollars in upfront costs and make it prohibitively expensive for outside groups to stop the government from violating the law. Judges have uniformly expressed their, let's say, annoyance with that at minimum, including Judge Ilston, who said plaintiffs shall post a bond of $10 total, not per plaintiff, by no later than November 4th, 2025.
Yeah, I would read that as two big middle fingers.
Me too. Second point, the government argued that the injunction, barring future reductions in force during the shutdown, should only apply to union members. That's a call out to the Supreme Court's brazen attack, essentially gutting universal injunctions. Remember, after letting judges in East Kakalaki block Biden's entire agenda for 4 years, the Supreme Court's conservatives somehow discovered this summer that nationwide injunctions are almost always unlegal. Again, we see trial judges adapting to the world that Chief Justice Roberts and his howler monkeys have created. So Judge Ilston said the fact that non-union members would benefit incidentally was not relevant to the definition and scope of the injunctive order. The RIF applies to all agencies. And third, this is why we have unions.
100%. There is power in a union, like the song says. And look, this is what the union does. And in a very precarious moment that we find ourselves, the union members got it done.
Yep.
Okay, we're going to take a quick ad break unless you're a subscriber at patreon.com/lawandchaospod or at lawandchaospod.com, in which case you will not be having an ad break. Not today, not ever.
And we're back. We have good news about Trump's efforts to federalize the National Guard and deploy them to the streets of American cities. For now, that's not going to happen. It's not going to happen in Chicago, and it's not going to happen in Portland, and maybe we will get protections so it does not happen anywhere. I mean, I don't want to get too optimistic. Look, we hit a low point on October 20th. That is when a panel of the Ninth Circuit with 2 Trump appointees on it ruled 2-1, coincidentally, that the president was indeed likely to prevail on the merits of his argument that he was unable with the regular forces to execute the laws on the streets of Portland, Oregon, even though he was, and quite obviously still is, able to execute the laws on the streets of Portland, Oregon. Judge Susan Graber penned an impassionate dissent. We have quoted it here several times. I'm going to quote it again. She said, I urge my colleagues on this court, meaning the Ninth Circuit, to act swiftly to vacate the majority's order before the illegal deployment of troops under false pretenses can occur. Above all, I ask those who are watching this case unfold to retain faith in our judicial system for just a little longer.
And there's not a lot of faith to be had right now, but in the 10 days since then, we got good news out of both the Ninth Circuit and potentially the Supreme Court. Because as Judge Graber requested, her colleagues on the Ninth Circuit did indeed act swiftly to vacate the majority stay order in the Oregon v. Trump National Guard deployment case. A judge immediately called for a vote to reconsider that decision en banc. And 8 days later, they voted to rehear. So they vacated the panel decision by those 2 Trump appointees, which prevents Trump from deploying troops in Oregon. Okay, so here's what's about to happen. Usually, rehearing en banc means by the full court rather than by the 3-judge panel. But the Ninth Circuit is huge. There are 29 active judges and 23 senior judges, and they have a local rule, Rule 40-3, which says the en banc court shall consist of the chief judge of this circuit and 10 additional judges to be drawn by lot from the active judges and any eligible senior judges of this court. And that last part is important.
It is, because we've told you on this show that the vote to reconsider en banc was left to just the active judges, and the Ninth Circuit is not as liberal among the active judges as you might otherwise think. Of the 29 active judges, it's split 16 to 13 Democratic appointees to Republican appointees, and 10 of those 13 Republican appointees are Trump appointees. But if you're wondering what the panel might look like now that they have voted to reconsider en banc and now that it includes eligible senior judges, I would point out that the senior judges there are 23 more of them, like you said, Liz, and they are 14 to 9 Democratic appointees. So a bigger margin. And I got to do the breakdown. It is 1 Obama appointee, 4 George W. Bush appointees, 10 Bill Clinton appointees, 2 by George H.W. Bush, 2 by Ronald Reagan, 3 by Jimmy Carter, and 97-year-old J. Clifford Wallace, who was appointed to the Ninth Circuit back in 1972 by Richard Milhouse Nixon.
Amazing. And look, to be clear, we've talked a lot about judges, particularly in the D.C. circuit, these senior status judges that we call the old bulls, often who were appointed by Republicans like Reagan, say...
Not too many Nixon.
Oh, yeah, no, not too many of those. But they've often taken a sledgehammer to Trump's arguments because they're so offensive, right? Because they are not MAGA. I mean, they're Republican, they're conservative, but they're certainly not MAGA. So, among those 9 Republican appointees, I would take my chances with the old bulls, particularly in a case like this. And one last wrinkle. The end of Circuit Rule 40-3 says, in appropriate cases, the court may order a rehearing by the full court following a hearing or rehearing en banc. So, maybe it's not over.
Maybe. I mean, I guess if the en banc panel turns out to be bad, theoretically, there's a full 52-judge en banc option. But I should tell you that the Ninth Circuit has never exercised that last provision for a rehearing by the full court. I cannot imagine that would be a live option. But it's there in the rules, so, theoretically.
Yeah. Okay. But in practical terms, Judge Immergut's TRO remains in effect. Trump cannot deploy Oregon's or any other state's National Guard units to the streets of Portland. Because remember, after there were 2 TROs, because the first time she, barred him deploying the Oregon National Guard, and he said, no problem, I'll send in California and Texas. And that was why there are 2 TROs. Meanwhile, the trial on the merits of this federalization began on Wednesday. It's a 3-day bench trial, ongoing as we record this.
Yeah, Liz, you and I have listened to some of that trial, and so far it has been workmanlike, right? And that's because the facts really aren't in dispute, right? That there was basically no violence in September when Trump issued that federalization order. There were sporadic violent protests back at the ICE facility in June. So both sides are going to elicit the testimony that they want. And the question is, how does that fit into the court's legal analysis? We get a pretty good idea where Judge Immergut thinks it falls. Okay, so that's how the Ninth Circuit saved Oregon for now. And the very next day, the Supreme Court saved Chicago? ?
Oh, I wouldn't go that far, at least not yet. But for background, on October 9th, Judge April Perry of the Northern District of Illinois issued a temporary restraining order barring the Trump administration from federalizing that state's National Guard and deploying them to the streets of Chicago. The Trump administration appealed to the Seventh Circuit, and a 3-judge panel mostly upheld Judge Perry's order. So Trump was not allowed to deploy the troops. They said, no, this is not an emergency. You're not unable to execute the laws. Calm down. Trump did not calm down. Instead, he raced to the Supreme Court and asked his buddies in the 6 conservative justices who mostly give him what he wants to do it again and let him flood Chicago with troops on the theory that it was in rebellion or he was unable to execute the laws. But this time, the 6 justices didn't give it to him, or they haven't given it to him yet. Mm-hmm. They did not issue the requested immediate stay. And you and I talked, Andrew, last week that we assumed that they were going to Friday news dump it on the shadow docket, give him what he wanted. That did not happen. And on Tuesday, we said we thought somebody was probably penning a furious dissent.
Yeah, we were praying for Alito, but worried that it was Sotomayor.
Yeah, but I mean, as time passed, we kind of shifted to thinking it must be Alito because they wouldn't wait for Sotomayor, right? The 6 conservatives, if they were going to bless it, would just do it and would say, hurry up, Sonia. That's not what happened. Instead, on Wednesday, the Supreme Court issued an order kicking the can down the road. It did not grant a stay. Instead, it requested supplemental briefing on the meaning of the term regular forces in 10 U.S.C. Section 12406, which is the federalization statute. So they're going to think about it some more. And the court ordered that briefing to be completed by November 17th. So in terms of the shadow docket, that means that Judge Perry, the trial judge's TRO, as modified by the Seventh Circuit, will remain in force, at least until the 17th, which is a good long time.
Yeah.
And all right, we're going to come back and talk about the legal analysis undergirding this after this brief ad break.
And we're back. 3 things I want to highlight about the Supreme Court's supplemental briefing order. First, I know our expectations of the Supreme Court are very, very low at this point, and rightfully so, but this is a win, right? In all of 2025 to date, the Supreme Court has only stood up to Trump, by my count, twice, right? Once was on May 16th when it reversed the Fifth Circuit in the middle of the night and prevented Donald Trump from engaging in more lawless Alien Enemies Act deportations to El Salvador. That seemed like that was a bridge too far. And then once on October 1st when the Supreme Court left intact a trial court injunction that prevented Trump from firing Federal Reserve Board Commissioner Lisa Cook for reasons that maybe we can infer have to do with the justices' 401ks, right? That is it. Other than those 2 reversals, the Supreme Court has stayed every other lower court temporary restraining order and preliminary injunction seeking to rein in Trump's lawless behavior. It hasn't decided anything on the merits, right? But by blocking those injunctions, it has left Trump free to basically destroy the government in the meantime. He's been able to fire unfireable officials, eliminate congressionally created executive branch agencies and gut those that he couldn't eliminate, withhold congressionally allocated funds that he was required to spend on domestic programs and foreign aid, impose tariffs. Now, the merits of all of those cases are still pending, but as you and I say on the show all the time, for most of them, it will not matter. You cannot unscramble most of these eggs. And that's what we mean when we talk about making consequential decisions on the shadow docket. So, point 1, at least the Supreme Court is not going to use the shadow docket to allow Trump to invade American cities.
I mean, at least not yet, right? I mean, okay, in theory, they could on the 17th. And to be fair, they did let him do it in California, right?
Point well taken on both of those. Okay. Second point is that on the merits of the statute, 10 U.S.C. Section 12406, that sets, as we have talked about on the show quite a lot, 3 preconditions for when the president can call state National Guard units into federal service. 1, if there's an invasion. 2, if there's a rebellion. Or 3, if the president is unable with the regular forces to execute the laws of the United States. And we've obviously concentrated on that third argument. But the Trump administration has made 2 even more expansive arguments justifying its use of federalizing National Guard units. One is the claim that the president's determination under that statute that any of those preconditions exist is unreviewable by any court. It is not justiciable. It doesn't matter what the actual facts are. The other argument is that in addition to being unable to execute the laws, that there is an ongoing rebellion in these cities where there are protests at ICE facilities. Now, those arguments are, to use the technical legal phrase, very, very dumb, right? But at least one judge, Judge Nelson in the Ninth Circuit, has signed on to both of them, right? He wrote a concurrence. We just talked about the panel opinion in Oregon v. Trump that got vacated by the full Ninth Circuit. Nelson wrote this concurrence that was just right-wing virtue signal. He cited to John Yoo, for example, right? This was just saying, ooh, Donald Trump, if you get a vacancy on the Supreme Court, pick me, I'll give you what you want, right? And in that concurrence, Nelson said that the courts could not review the president's determination to federalize National Guard units. And he also added in for good measure that Portland was in a rebellion, just like the Whiskey Rebellion of 1794. And my point here is that I think if there were 5 or more votes on the Supreme Court for either of those maximalist arguments, you wouldn't need additional briefing on what the regular forces means for subsection 3 of 10 U.S.C. 12406, right? Like the howler monkeys would just say, non-justiciable, send in the troops, or there's a rebellion, send in the troops. So I take it as a second good sign that I think Judge Nelson's view does not have 5 votes at this Supreme Court. What do you think, Liz?
Yeah, I mean, I think that's right. You know, if they were going to do it, they'd have done it, and they're clearly not going to do it. I think it's interesting that it took them this long to get there, which makes me think that it's not 6-3, but 5-4, and somebody in the middle is having, you know, is trying to dance at 2 weddings with one Torres, as we would say. And you know, that's not too hopeful, but we'll see how it goes.
I think that read is correct. I would endorse that. And third point, there is an actual conflict among the circuits right now as to what Congress meant in subsection 3 when it said unable with the regular forces to execute the laws. And if we had a real Supreme Court, I would want them to weigh in and decide, right? Because every judge other than Judge April Perry in Illinois has interpreted that phrase, regular forces, to mean regular law enforcement, right? So those courts interpreted the relevant factual question, undergirding whether to issue a temporary restraining order or preliminary injunction or not, was could ICE do its job on the streets either on its own or with the protection of state and local cops?
Right. I mean, objectively, yes, they can. But if Trump says they can't, are courts allowed to look at it, right?
Right. Judge Perry took a different approach. She said, based on a textual analysis of what that phrase meant at the time that it was enacted, that regular forces meant the military. Right? So her view of the 3 subsections of 12406 is that they all refer to the same underlying condition and response, right? So if there's an invasion or there's a rebellion or there's a total breakdown in the law, then the president is commander-in-chief. He can try and use the regular forces, the military, first to repel the invasion, quash the rebellion, or restore order. That's what the statute means by regular forces. And then, if he's unable to restore order with the regular forces, he can get additional forces by federalizing the state National Guard on an emergency basis. And then Judge Perry held that because Trump didn't even try to use the regular forces to restore order, he can't ask for more. You can't jump to that emergency condition.
Yeah, I don't love this reading, honestly. Yeah. I don't think it's how 12406 has ever been interpreted, right? The Posse Comitatus Act prohibits using the military to enforce the civil laws. So if, like, the military was the first line of defense, that wouldn't make a lot of sense. And on a practical level, are we really talking about telling Trump to use the military first and then maybe National Guard? Like, don't love that one.
Yeah, I hear you. And I think so did the Seventh Circuit, right? They looked at Judge Perry's opinion and they bracketed the issue of what constitutes the regular forces. They called it thorny and complex, which, true, it is. And then the Seventh Circuit said, look, no matter who's right as to what that phrase means, the government hadn't met its burden under either standard, right? Under either the failure to use the military or the Ninth Circuit standard being unable to with the regular law enforcement forces. I do have to say, again, right, legal geekery from a principle of statutory construction, like Judge Perry might have gotten it right. But we will know in 2 weeks if the state of Illinois is going to adopt her idiosyncratic view of what constitutes regular forces, whether they're going to go along with the Ninth Circuit or come up with something else entirely. And I should add that there are subsidiary issues here in addition to the briefing as to what that phrase means, right? Like questions like, is unable in 12406, does that indicate an objective legal determination about ability that would be made by the court, or a subjective one to be made by the president? I thought the Ninth Circuit's dissent in the prior panel opinion really set that issue out really clearly. The standard of deference to be owed, right? Like there's a lot of law to be done here. And again, I don't have a lot of confidence that the Supreme Court is going to get it right, but that's where we are.
Okay, it's a lot to think about, and we will be right back. And we're back in the Eastern District of Virginia, where the prosecution of former FBI Director Jim Comey appears to be falling apart before our eyes.
It's like a sandcastle with the waves beating against it. Soon it will just wash away.
I think that's right, although the ignominy will remain forever. Okay. There were several motions filed today. 3 we're going to talk about substantively, and then we'll talk about another related motion to disqualify Lindsey Halligan in the subscriber bonus at the end. But first, I want to point out the defect at the center of this case, because it's really the thing that's animating all of this. Mm-hmm. And it's that the bare bones indictment fit 2 different fact patterns. Remember, Comey is charged with lying to Congress in September of 2020. Actually, I'm going to play the clip of this exchange, which is the basis of this indictment.
Yeah.
All right, let's shift to another topic. On May 3rd, 2017, in this committee, Chairman Grassley asked you point blank, quote, have you ever been an anonymous source in news reports about matters relating to the Trump investigation or the Clinton investigation? You responded under oath, quote, never. He then asked you, quote, have you ever authorized someone else at the FBI to be an anonymous source in news reports about the Trump investigation or the Clinton administration? You responded again under oath, no. Now, as you know, Mr. McCabe, who works for you, has publicly and repeatedly stated that he leaked information to the Wall Street Journal and that you were directly aware of it and that you directly authorized it. Now, what Mr. McCabe is saying and what you testified to this committee cannot both be true. One or the other is false. Who's telling the truth?
I can only speak to my testimony. I stand by what the testimony you summarized that I gave in May of 2017.
So your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct?
Again, I'm not going to characterize Andy's testimony, but mine is the same today.
So that was Ted Cruz questioning Comey about whether he authorized his deputy, Andy McCabe, to speak to the Wall Street Journal off the record. But the language of the indictment also fits a second fact pattern for which Comey was also investigated.
And not charged, we should say. Remember, Donald Trump spent years in his first term trying and failing to indict Comey for leaking.
Indeed. So, okay, the second fact pattern involved Comey's friend and lawyer Daniel Richman, who is a law professor at Columbia University. And when the indictment dropped, no one, including Comey, knew which theory of the case it was under. And the indictment said that he had, quote, falsely stated to a U.S. senator during a Senate Judiciary Committee hearing that he had not authorized someone else at the FBI to be an anonymous source in news reports regarding an FBI investigation concerning Hillary Clinton. That statement was false because, as Comey then and there knew, he in fact had authorized Person 3 to serve as an anonymous source in news reports regarding an FBI investigation concerning Clinton. So was Person 3 McCabe? Was he Richmond? Comey says he only found out a week after the indictment that it was Richmond.
Which never made any sense. I mean, you guys just heard the clip, heard the colloquy, right? Like, Ted Cruz was very clearly asking Comey about Andy McCabe. And so that disconnect is the fatal defect at the center of this case. And it is the basis for the 3 motions that were filed today as we record the show. The first is a motion for a bill of particulars, which is basically a motion to make the prosecutor hand over a more detailed explanation of the factual allegations that are in the indictment. And look, criminal defendants file these motions all the time, and they almost always lose, right? They're mostly denied, but mostly you have experienced prosecutors who lay out a coherent set of facts in the indictment they get from the grand jury. And this is just a page and a half that says, count 1, lied to Congress, and count 2, obstructed by lying to Congress. So here's how Comey puts it. The indictment, in its current form, sheds no light on the alleged factual basis for the conduct at the heart of Count 1 and provides no information about what statements or conduct underlie Count 2.
And he's right? No one reading it knew until Comey said in one of his motions that this indictment was about Richmond. Or
we didn't.
People pretty much thought it because, right. Or I think people pretty much inferred it because McCabe publicly said that he hadn't spoken to prosecutors, so by process of elimination, but you didn't know it because you read the indictment. So Comey filed this motion for a bill of particulars to force the government to articulate stuff like, when did this supposed authorization to speak to the media happen? What form did it take? Was it an email? Was it a signal message? Was it carrier pigeon? Who did Richmond allegedly leak to? And most importantly, what exactly did Comey say under oath that was false? Right?
Yeah.
Which actually, that's a great segue to the second motion, which is captioned as a motion to dismiss indictment based on fundamental ambiguity and literal truth, aka a Bronston motion.
Oh, I hear my walk-up music, Liz. So, Bronston v. U.S. is a 1973 Supreme Court decision that is near and dear to the hearts of every trial lawyer, myself included. Here's what happened. During bankruptcy, movie producer Sam Bronston was asked by lawyers for one of the creditors in the bankruptcy whether he, Bronston, was hiding assets. So here was that exchange. The lawyer says, question, do you have any bank accounts in Swiss banks, Mr. Bronston? Answer, no, sir. Question, have you ever? Answer, the company had an account there for about 6 months in Zurich. Question, have you any nominees who have bank accounts in Swiss banks? Answer, no, sir. Question, have you ever? Answer, no, sir. Okay. And as it turns out, Bronston had indeed had a personal Swiss bank account, but he closed it right before the bankruptcy, right? So he answered every one of those questions truthfully, but evasively, right? The full answer to have you ever should have been yes, but Bronston didn't say yes. He didn't say no either. What he said was, oh, the company had one. And then the lawyer for the creditor did not perceive that disconnect in between the question he'd asked and the answer that was given, and he just moved on. Later, the bankruptcy court discovered through other means that Bronston had indeed misled everybody and had a Swiss bank account, and the bankruptcy court referred Bronston to the Department of Justice for perjury charges, which were brought and for which he was later convicted. He appealed all the way up to the Supreme Court, which reversed 9-0, right? The court held that if a witness gives an answer to a question that is literally true, that is an absolute defense to the crime of perjury. And relatedly, Comey is charged with 18 U.S.C. 1001, making a false statement. They overlap. And that's true even if the witness has evil intent, even if the implication of the answer that they give is misleading or evasive. Here's what Chief Justice Warren Burger said in that opinion. If a witness evades, it is the lawyer's responsibility to recognize the evasion and bring the witness back to the mark, to flush out the whole truth with the tools of adversary examination. And as a trial lawyer, this was drilled into me. This precise case, even though I was doing civil and not criminal litigation, was drilled into me at an early age as a young associate, right? And the lesson was the court is not going to bail you out if you, Mr. Torres, ask a badly phrased question or if you fail to follow up when a witness doesn't give you a direct answer.
Right. So back to Comey. This indictment alleges that Comey gave false answers to two questions from Ted Cruz that we played at the beginning of the segment. The first was when Comey asked, as between Comey and Mr. McCabe, who is telling the truth? This is how Comey's lawyers argue this, right? Because a Bronston motion is about actual truth, and they're saying what we said was actually true. So they say a direct answer to this question would have required Mr. Comey to respond either I am telling the truth or Andrew McCabe is telling the truth. Mr. Comey, however, did not respond by stating who was telling the truth. He stated, I can only speak to my testimony. I stand by the testimony you summarized that I gave in May of 2017. Although those statements did not respond directly to Mr. Cruz's question, they were literally true. The same is true of Mr. Comey's answer to Senator Cruz's second question. Senator Cruz asked, so your testimony is you've never authorized anyone to leak. And Mr. McCabe, if he says contrary, is not telling the truth. Is that correct? A direct answer to this question would have required Mr. Comey to state either correct, Andrew McCabe is not telling the truth, or incorrect, Andrew McCabe is telling the truth. Mr. Comey said neither of those things. He instead stated that he was not going to characterize Andy's testimony, but mine is the same today. Again, that response is literally true. Mr. Comey, in fact, did not characterize Mr. McCabe's testimony, and his statement that his testimony is the same today simply meant that he did not intend to revisit his prior testimony. That was a literally true statement, regardless of whether the prior testimony was itself truthful.
Yeah, and we should be clear here that Comey, in this motion, repeatedly says that he was telling the truth in those answers, right? But that's not relevant for purposes of the motion to dismiss. You can assume that he wasn't telling the truth. He could have been deliberately evasive and squirrely and misleading. And under Bronston, the onus is on Ted Cruz to ask better questions. As Comey's lawyers put it, fundamental to any false statement charge are both clear questions and false answers. Neither exists here. Because, and I should expand on that a little bit, in addition to the Bronston argument, there's kind of a wider claim that Cruz's questions were susceptible to multiple interpretations, which, again, we can vouch for because we interpreted them differently when we first read that indictment.
Yeah, I think most people, us included, assumed that this was about McCabe, since clearly the questioning was about McCabe. And there were so many problems. I mean, this case wouldn't be better if it was about McCabe because
right.
McCabe, they already got no build on McCabe. They already tried to charge McCabe. I mean, there were so many problems with that case too. But I mean, to be fair, it wouldn't kind of be relevant to this motion for actual truth, the Bronston motion. But with respect to the rest of it, I think the major flaw in this indictment is clearly that Cruz wasn't talking about Richmond. He was obviously talking about McCabe. So to charge Comey for lying about Richmond based on this conversation doesn't make any sense at all.
Yeah, I agree with you.
Okay, we're going to take one more brief ad break, and then we will come back and talk about the third motion filed today. And we're back. Okay. As we said, there were 3 motions filed in the Comey case today, and the third was a request to release the grand jury transcript.
Right. Normally, grand jury transcripts are secret. That is Rule 6E of the Federal Rules of Criminal Procedure, and it is pretty sacrosanct, right? But there are limited conditions under which courts can order the disclosure of grand jury testimony, and One of those is at the request of a defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury, right? So if the prosecutors have done something improper, you can invade the secrecy of the grand jury, discover that, and then use that as a basis for a motion to dismiss. It almost never happens that you get even to the inquiry phase, but once again, Comey has an unusually strong case here.
Yeah, and it's because of what we said was the fundamental problem at the center of this case, right? Halligan returned an indictment that is so vague that it could fit multiple fact patterns. Mm-hmm. So they say the indictment omits Senator Cruz's words that explicitly narrow the focus of his questions to Mr. McCabe and misleadingly implies that the questioning related to Mr. Richmond. And thus, they say they should be able to see the transcript of the grand jury proceedings to see how Halligan characterized it to the grand jurors, because maybe she left out one or two important details.
Yeah, and let's say alone, that almost certainly would not be anywhere near enough to get you over the hump of disclosing confidential grand jury materials, right? But it is not alone.
No, it's definitely not. I mean, look, everything about this indictment is crazy, right? We are coming off of years of experienced prosecutors in the Eastern District of Virginia and in D.C. saying there is no case here because God knows Trump tried to find one. Trump has been publicly braying for Comey's indictment. You have Halligan's predecessor, Eric Siebert, who was pushed out because he refused to do it. You have Halligan, who's never prosecuted a case in her life, getting appointed, probably unlawfully, which we've talked about and we're going to talk about in the subscriber bonus. And then 4 days after Halligan got appointed, she emerged with an indictment that looks like this.
Yeah, reading between the lines, you can really see Pat Fitzgerald and Comey's lawyers kind of dancing around without saying, sure, Your Honor, a normal prosecutor may be entitled to a presumption of regularity, but come on, this goofball's a political hack, and the first time she was ever inside a grand jury room, she came out with this defective piece of crap? Come on.
Yeah, and it's not just that she's a political hack, right? The circumstances of the grand jury returning this indictment reek to high heaven, right?
Yes.
She got no billed. The grand jurors rejected the first version of this indictment. She did not release them. She kept them there until 6:45 p.m., which is much later, right? In addition to which, no other lawyer from the Eastern District of Virginia was willing to sign the indictment or reportedly present it to the grand jurors, which is another reason that, you're not going to afford her the presumption of regularity, right? She has no experience. How does anybody know that what she did was right? And the transcripts show that she didn't even understand how to present the indictment to the federal magistrate. Like, she handed her the wrong piece of paper. She answered the questions wrong. It's just all of these things together raise a very strong inference that something hinky happened here.
And on top of all of that, it looks like the FBI investigator whom Halligan had testify to the grand jury may have been tainted by exposure to privileged materials. Remember, we talked on Tuesday's show about the argument over a filter protocol for materials seized during earlier investigations pursuant to 4 search warrants, particularly Daniel Richmond's phone and computer. The government wanted to have its own agents sorting through and flagging stuff that might be privileged, and Comey said, hell no. He wants to challenge that underlying warrant before the government starts picking through that stuff, which, again, is presumptively attorney-client privilege, right? Daniel Richmond was his lawyer. And Judge Nachmanoff agreed. He assigned a magistrate judge to adjudicate the privilege dispute over the stuff that was seized 7 years ago. But in that motion, mostly under black redaction bars, there was something about the government having already snuck a peek at that disputed evidence.
Right. And here's what this motion to unseal the grand jury transcript says. It says, Ms. Halligan appears to have called one of the lead FBI case agents as a witness. The same day the agent testified in the grand jury, he alerted the FBI Office of the General Counsel, quote, and then there's a really long redaction, end quote, involving Mr. Comey and his attorneys. The FBI Office of the General Counsel subsequently informed the agent that, another long redaction, in this case. Despite his apparent awareness of his potential exposure to privileged material, the agent nevertheless apparently served as a witness presenting evidence to the grand jury in this case. And I should say that person's name is going to come out. It's Miles Starr, and I think he's a character we're all going to get real familiar with.
Yeah. Look, this is one of the many problems with bringing an investigation that no experienced prosecutor would touch, right? And that is, no one will tell you that you are about to run into a buzzsaw, and also you run out of staff.
Right. I mean, you run out of staff, and you literally have to use people both to present to the grand jury and to wade through stuff, and they wound up getting tainted in some fashion, right? Okay. Well, Comey and his lawyers are not going to get to see that grand jury transcript yet because that motion hasn't been adjudicated, although it is the rocket docket and Judge Nachmanoff has been ruling really fast. But someone is going to get to see that, and we will talk about that along with the increasing likelihood that Lindsey Halligan is about to find herself out of a job in our subscriber bonus. You guys know how to access that stuff. If you want to become a subscriber, hit us up at patreon.com/lawandchaospod or lawandchaospod.com. That's our Substack. And if you want to support the show, you can always leave us a 5-star review on your podcast platform of choice. Otherwise, we will be back Monday with written content and on Tuesday with another podcast. Have a lovely weekend. I know everything is on fire all the time, but it is fall and it is beautiful and the air is clear and it's not even hot. So get out there and enjoy it. Thanks, guys. We'll see ya.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.